In particular, in light of the entire evidence, the majority was satisfied beyond reasonable doubt that Rasim Delić had reason to know that members of the EMD were about to commit or had committed the crime of cruel treatment against these detainees. However, as explained in more detail in the judgment, the majority found that the information available to Rasim Delić about the propensity of EMD members to commit crimes had not been sufficiently alarming to put him on notice that the crime of murder might be committed by such members. The majority also found that Rasim Delić had failed to take the necessary and reasonable measures to prevent the crimes in July and August 1995, and after the commission of those crimes, to punish the perpetrators thereof. In this regard, the majority was satisfied that there is no evidence to indicate that Rasim Delić had reacted in any way to the information contained in Bulletin 137 of the 22nd of July 1995 about the capture of VRS soldiers by the EMD. Nor is there any other piece of evidence which would suggest that Rasim Delić attempted to find out more about the fate of the detainees in the custody of the EMD. As regards the crimes committed in Kirsten and the Kamenica Camp in September 1995 by EMD members, the evidence shows that the Main Staff Security Administration received a report from the Security Service of the Third Corps on the 16th of September 1995. This report forwarded an intercepted fax of the EMD stating that, quote, the Mujahedin gained ground and entered a group of Serbian villages and took 60 prisoners after the killing, unquote. However, this information was not included in the bulletins sent to Rasim Delić. Rather, the report of 16th September 1995 was eventually deposited with the Counterintelligence Department of the Security Administration. There is no evidence that Rasim Delić had information in his possession that the EMD had taken captives, much less that any crimes were committed against them. Contrary to the prosecution's contention, the majority was not satisfied that the Security Administration of the Main Staff or any other source had informed Rasim Delić of the capture and killing of the captives. The majority noted that, unlike the bulletins which had been provided specifically to Rasim Delić, there is no evidence that information in the possession of the Third Corps and the 2 articles published in ABiH Gazette was available to Rasim Delić, or that the information contained therein was brought to his attention. Finally, the majority examined the number of bulletins received by Rasim Delić during the period from August to September 1995 containing information on criminal behavior of EMD members. However, the majority found that in the absence of evidence that Rasim Delić had known that Bosnian Serb soldiers and civilians were detained by the EMD, the information contained in the bulletins alone was insufficiently alarming to put him on notice of the risk of the crimes committed in Kirsten and the Kamenica Camp in September 1995. The majority found that it could not be concluded beyond reasonable doubt that Rasim Delić had reason to know that the EMD was about to commit or had committed the crimes of murder and cruel treatment against Bosnian Serb soldiers and civilians in Kirsten and the Kamenica Camp in September 1995. To sum up, the majority only found beyond reasonable doubt that Rasim Delić, as a superior, had reason to know of the crime of cruel treatment committed by EMD members against 12 VRS detainees and had failed to prevent and punish this crime. Rasim Delić, therefore, incurs individual criminal responsibility for the crime of cruel treatment under Article 7.3 of the statute. The majority now turns to the matter of sentencing. In relation to the gravity of the crimes, the majority, amongst others, recalled the appallingly brutal nature of the acts of mistreatment against the 12 VRS soldiers, which had lasted more than 1 month, and the physical and mental suffering that the victims had endured while subjected to such abysmal treatment during their detention in Livade and the Kamenica Camp. The majority also noted that the victims had been detained under strict guard of the EMD. This situation rendered the victims particularly vulnerable. The majority was also mindful that it had found Rasim Delić to have had imputed knowledge of these crimes as opposed to actual knowledge. The prosecution submits that the fact that Rasim Delić held, quote, the highest military position, unquote, in the ABiH must be considered as an aggravating circumstance. The majority, however, recalled the appeal chamber's holding that, quote, in the context of a conviction under Article 7.3 of the statute, use of the superior's position of authority as an aggravating circumstance would be inappropriate since it is itself an element of the criminal liability, unquote. It is the superior's abuse of authority that may be taken into consideration. In this case, there is no evidence suggesting that Rasim Delić abused his authority. As a mitigating circumstances, the majority took into account the voluntary surrender of Rasim Delić, his family circumstances, the absence of a prior criminal record, and his good character as represented by, among others, his efforts to disseminate international humanitarian law within the ABiH and his substantial involvement in the negotiation of peace accords, including the Dayton Agreement. The majority also took into consideration the fact that Rasim Delić had faced a number of extraordinary challenges and difficulties from the moment he took office as ABiH main staff commander on the 8th of June 1993, including the lack of organization and equipment within the ABiH and a number of senior officers who had not immediately accepted the authority of Rasim Delić. Mr. Delić, would you please rise? This trial chamber, having considered all of the evidence and the arguments of the parties, and based upon the factual and legal findings as determined in the judgment, unanimously finds you, Rasim Delić, not guilty pursuant to Article 7.3 of the statute, and therefore acquits you of the following counts. Count 1, murder as a violation of the laws or customs of war pursuant to Article 3 of the statute. Count 2, cruel treatment as a violation of the laws or customs of war pursuant to Article 3 of the statute in relation to the events in Bikoshi on the 8th of June 1993, as well as the events in Kirsten and the Kamenica Camp in September 1995. Count 4, cruel treatment as a violation of the laws or customs of war pursuant to Article 3 of the statute. The trial chamber, by majority, Judge Moloto dissenting, finds you, Rasim Delić, guilty pursuant to Article 7.3 of the statute of the following count. Count 2, cruel treatment as a violation of the laws or customs of war pursuant to Article 3 of the statute in relation to the events in Livade and the Kamenica Camp in July and August 1995. The trial chamber, by majority, Judge Moloto dissenting, hereby sentences you, Rasim Delić, to a single sentence of 3 years imprisonment. You have been in custody for 488 days. Pursuant to Rule 101C of the rules, you are entitled to credit for the period of time you have been in custody towards service of the sentence imposed. Pursuant to Rule 103C of the rules, you shall remain in the custody of the tribunal pending the finalization of arrangements for your transfer to the state where you shall serve your sentence. Judge Moloto appends a dissenting opinion. He also places on record that he participated in the deliberations on and agreed with all findings on Rasim Delić's notice and failure to prevent and punish. However, based on his conclusion on effective control, as detailed in his dissenting opinion, he dissented from the sentence that the majority imposed on Rasim Delić. That concludes the judgment. Court adjourned.
All rise. We will wait.